conscience. That's not my conscience. It's the president's conscience. When he's accused of corruption in his CDF and is taken to court, then the courts are bad. When the courts rule against him, when he's involved in corruption for CDF, then the courts are bad. When the courts rule that, first of all, the other day, these things were canvassed as we watched in High Court. You know, the High Court in Kirinyaga had stopped what was a political process, as envisaged in the Constitution. Then it was canvassed, and then the court, the same court, with a 3-judge bench, overturned the decision that was done in Kirinyaga. At that point, when the court order is given in Kirinyaga, then the courts are good. When a 3-judge bench sits in Nairobi and overturns that stoppage of the stay of the proceedings, then the court is bad. I think we must understand that the lens from which we view the law will always be subjective, depending on where you sit. But we must allow the courts to do their work.
And if you're not happy, you seek redress.
And you seek redress. And you know, in some of these cases that the appellate courts, both the Court of Appeal, depending on where the issue came from, both the High Court, Court of Appeal, and the Supreme Court, as appellate courts, are not interested in facts. They just deal with matters of law. And therefore, we can't decide when the law is good, when the courts are good, and when they're bad, depending on where we sit.
Okay. Yes, Banhash.
Late, great Justice Brandeis, American jurist and judge, who was a progressive, but explained the meaning of the Constitution of the United States and the judiciary. The judiciary must have reach. It's exactly the opposite to what our president is saying here. The job of the judiciary is to interfere. The job of the judiciary is not to